All right. Welcome back, everybody. I hope you are all well. Any questions? Anything in your mind before we get started? No? Okay. So today's going to be a bit of an unusual class. I'll probably teach this class once, and next year will be very different. I always like to, where possible, go over a current case. The risk of going over a current case is I don't know how it's going to be decided, right? Duh, of course, right? I have no idea. In fact, the court could decide the case tomorrow for all we know. Probably won't, but it could. So what I try to do is to at least bring you up to speed where the law is right now and give you some insights into perhaps what are the competing sides of this position. So I gave you a couple readings. One, I gave you a blog post from SCOTUSBlog. If you don't read SCOTUSBlog, you should. It's an excellent website, and they summarize all of the pending Supreme Court cases. It's very well done. It's a professional outfit. I also gave you the briefs filed in this case from both the petitioner as well as the respondent, the city of Philadelphia. I didn't make you read the entire brief. You're welcome. I think that would have been way too onerous. But I picked specific portions that I think help to illustrate the different approaches to this question. Now, Supreme Court briefs do not always give equal weight to equal sides. The reading from one brief was about 15 pages, and the other brief was like 5 or 6 pages. And that's not because I tried to diminish it. It's because one side really wants to overrule Smith, the other side doesn't. So, they put different amounts of attention there. I mean, briefs are limited, right? You don't have unlimited words. So you have to pick your words carefully, especially for a Supreme Court brief. Every word, every sentence is scrutinized so carefully because the things you say in your brief can come back to bite you in the butt. So there's very good reasons why SCOTUS briefs are done in this fashion. Okay? All right, so let's try to go over the facts in Fulton, and let me try and give you some of the background. Okay, so we have a couple of cases we've studied so far, right? First, we have Reynolds. This was the case from the 1870s in which a member of the LDS Church challenged his conviction for polygamy on the ground that his religion required polygamy. Okay. Fast forward to the 1960s, and we have Justice Brennan's opinion in Sherbert. In Sherbert, you had the Seventh-day Adventist who refused to work on the Sabbath of his choice, which was Saturday. And the state sought to deny him some unemployment benefits. And in Sherbert, the court established these sort of two important tests. One was the compelling interest test, which means the free exercise of religion can only be burdened if there's a compelling interest. And the other test was called the least restrictive means test. In other words, if they are going to burden religion to pursue a compelling interest, they have to use the least restrictive means. That is the most narrowly tailored approach to accomplish that goal. Okay? Sherbert kind of made it up. It was classic Brennan, right? There was no precedent. It's sort of just, here's what it is, and this is our test, and don't ask me about it until later, right? It was just sort of made up of whole cloth. During the 60s and 70s and 80s, the Sherbert test became somewhat unpopular, especially among conservatives who didn't like the fact that the courts would be telling legislatures what they had to do. There's sort of a model of restraint, right? The court shouldn't be putting the legislature to such a onerous test. And then we get to Scalia in Smith. And Smith is one of these cases where it looks very different today than it did 30-something years ago. When Smith was decided, it wasn't considered terribly controversial at the time. Right away. It shortly thereafter became it, right? But Scalia saw nothing wrong with his decision, right? He said that courts cannot make religions, laws unto themselves, right? A religion cannot dictate exceptions. I think a couple of you make comments like this last class, right? How is it that the exact same conduct can be legal for one person, but legal for another person if motivated by faith? And I think a lot of you expressed discomfort with that. So I think you are sharing Scalia's concerns. Justice Scalia also seemed to think that the Sherbert test was unworkable, that it would give courts way too much power to enforce laws, and it would be very difficult for the courts to administer. Scalia also said that the Sherbert test wasn't needed, that the democratic process would be able to step in most cases and would be able to help those whose rights perhaps are not being secured. Scalia really saw no problem with this opinion. He was not an idiot, right? You may not like Scalia, but he was a smart guy. He made some predictions about how Sherbert would work and how his doctrine would work, and he made the decision that his doctrine is better. I'm pretty sure if you were to ask Justice Scalia in his deathbed which opinions he regretted, he probably would rank Smith pretty high up there. Scalia came around a couple other issues where he said I was wrong, and so he had an almost 30-year tenure, but he was fallible, and he admitted in a few places he probably screwed up. Almost immediately after Smith, we get a law passed by Congress called the Religious Freedom Restoration Act, RFRA, right? RFRA said, no, Supreme Court, you guys messed up. The Sherbert test is where it's at. That's the right test. And what the RFRA law said is for all federal and state laws, the Sherbert test will apply. That is, you need to show a substantial burden and the least restrictive means and compelling interest, right? But it wasn't exactly Sherbert, and in some regards, it was actually even stricter than Sherbert, because Sherbert was always sort of nebulous. Brennan did his thing, but the RFRA statute was very strict. However, the court said that RFRA went too far, that Congress could not restrict a state's police power based on the statute. Why? Well, this is a decision which I'm not a fan of, but the court says only the court can interpret the 14th Amendment, right? Congress lacks the power to interpret the 14th Amendment, and Congress can't go beyond what Smith said. In other words, whatever Smith said, that's the law. Take it or leave it. Actually, you have to take it. You can't leave it. Take it, right? That's the law. So the court held unconstitutional RFRA as applied to state governments. RFRA still existed as applied to the federal government, but not the state government. Why? Congress can limit their own power. They don't need the state's permission. They can limit their own power if they want to. So as things stood after Bernie v. Flores, actually from Bernie, Texas, not too far from here, near San Antonio, after Bernie v. Flores, the court says RFRA is okay for the federal government, but not for the states. Later, Congress enacts another law. This is my favorite acronym: the Religious Land Use and Institutionalized Persons Act, RLUIPA, RLUIPA. My favorite acronym. I love saying it. RLUIPA. It's fun, right? This applies to prisons and different cities except federal money. So if you are a prison, you have to basically treat your prisoners with the protections of Sherbert, right? So for a large section of society, if you're a prisoner and you're, for example, you're a Muslim inmate who's not allowed to keep his beard, right? You can bring a suit under RLUIPA against the federal government, right? And those suits are actually successful. If you're, a Jewish inmate who wants kosher food, you can bring a lawsuit under RLUIPA because you're an institutionalized person. You're a prisoner. This also comes up in land use, right? If you're a jurisdiction that accepts federal money, which even in state prisons, exactly, Jessica, it applies across the board, federal and state prisons. RLUIPA also applies for land use. Some of you may have had me for property. I think I mentioned this, but if you are a jurisdiction that accepts federal money, and you make a land use decision that burdens religion, you are subject to the Sherbert standard under the statute. So a church or a synagogue or a mosque can sue a city that denies a zoning permit based on some sort of religious burden. Now, these are spending clause problems. If you remember South Dakota v. Dole, right? Congress can give money to states and put strings upon them. And the court upheld these conditional spending programs, saying, look, if you don't want this money, don't accept these conditions. Of course, it's ridiculous, right? States can't turn down the money, but the Supreme Court's upheld RLUIPA. So as things stand now, for the federal government, you have RFRA. For state governments, you have RLUIPA, which limits prisoners, mostly prisoners, but also people like in old age homes they can use as well as certain land use decisions. But many states enacted what are called baby RFRAs, state RFRAs. So Texas has one in the state constitution. So if you sue the state of Texas for a free exercise clause violation, you are subject to the Texas RFRA, which again is more or less the Sherbert standard. Roughly half the states in the union have RFRAs, baby RFRAs as we call them, not like baby shark, sorry, I got a 2-year-old, baby RFRAs, right? Right? The baby RFRAs. But what about the other half of states that don't have them? New York, California, Pennsylvania, Colorado. I don't have the list at the top of my head, but those are the big ones because they've had SCOTUS cases involving laws from those states. In those states, as of now, March 24th at 1:41 p.m., you're still subject to Smith. The Smith rule still governs in those 25, I can't remember the exact number, 20-something states. All right. Pennsylvania is one of them. And this gave rise to the Fulton case. Okay. So any questions as a brief 10-minute thumbnail of the last 140 years of free exercise clause precedent? I think I got it all. Any questions on that? Yeah, Mike, go ahead.
I just want to get that right. So you said that if the state adopts a baby RFRA, then they're subject to Sherbert, but if they don't, they're subject to Smith?
Right. The state is voluntarily limiting itself to the Sherbert test.
Thank you.
I was hoping for a longer question. And just to be clear, it isn't exactly Sherbert. In some regards, it's actually stronger than Sherbert, for reasons we can talk about maybe later. But it's more or less the Sherbert test. Close enough, just for your notes. All right. So let's talk. We'll come back to Fulton in a few minutes. But I want to talk about a question someone put last week. I can't remember who it was. Someone asked me a question, which was a good question. What happens if the state, enacts a law that burns all religions equally? That is a issue that's come to light in the last, year and week or so. COVID, right? You're all sitting here on Zoom for a reason. I haven't left Houston in nearly a year. I used to travel 100,000 miles a year. I haven't left Houston in a year, right? It's changed so much of what we used to do. Historically, when religion was burdened, it was because there was some religious practice that the state considered harmful. So polygamy, for example, the state considered polygamy harmful, right? Peyote, right? I mean, not really, but people consider it to be a dangerous drug, whatever, right? So it was some religious practice, or might call it religious action, that was deemed harmful. But at all junctures, the government always said, of course, though, you can, pray, you can meet, you can worship, because you're not bothering anybody, right? There was no historical analog of limiting prayer itself, just assembly, gathering. Words were generally not considered harmful. If you were sacrificing an animal, then that triggered some other health issues, right? But if you're just sitting and meeting and talking and chanting and singing, that was not considered a dangerous act. Hello, COVID, right? It became the case that indeed simply being in the same room with someone else was considered dangerous, right? Was it 6 feet now? Or is it 3 feet now? Who the hell knows, right? But if you were, the numbers keep changing. If you were not within a certain amount of distance from someone else, and you were not wearing a mask of whatever quality mask you have to wear, you are considered a threat. No more collection plate. You got to use, a Zelle or something, right? You got to use, a Bitcoin. And in the immediate aftermath of the COVID epidemic, just about a year ago today, states began to shut things down, right? They shut down everything. Well, not everything, almost everything, right? Certain types of so-called essential businesses were left open, and that definition varied wildly. But one thing that was deemed non-essential in several states were houses of worship. In some states they were. In Texas they were. There was never any disruption of Texas. In fact, I think if there had been, they'd be sued under RFRA, which is why I think RFRA really makes a difference. But in states like Illinois, in New York, in California, and a couple others, there's only in Nevada, Colorado, and blanking, a couple other states, or a handful. Governors enacted widespread prohibitions on worship, where they said a house of worship can only fit no more than 10 people. And it wasn't just Jewish or Christian or Muslim, whatever. It was all gatherings, right? All gatherings across the board. And in some states, religious institutions were treated better. Maybe they could have 15 people instead of 10 people, right? So these cases were challenged under Smith. And the government said, look, these are neutral laws. We're not targeting any religion. We have no improper animus towards any faith. These are laws that apply to all gatherings across the board. Right? But still, in several states, houses of worship were pretty much shut down for months. Right? You may think, oh, just meet 10 at a time. Well, worship services take time. There's only 24 hours in a day. If you have a 1,000-member megachurch, you'll never get to all of your members. It's simply impossible. If you have 100 members, you can't fit them all in a day. There's certain holidays that have to be performed at specific times day. You can't stagger them, right? There's certain prayers beginning sunrise, sunset, right? So for some people, this was basically a complete prohibition on public worship. The state said, well, use Zoom, right? We can all Zoom over prayer. Well, not everyone can use electricity during their holidays. Some people have to turn off electricity. Jewish people in particular, they're not allowed to use Zoom on holidays. As I have a Passover state over Zoom this coming weekend, but not always the best. I don't give you these facts to try and argue about the COVID cases. I give you these facts to illustrate that Smith has been tested over the last year in ways that I think not even Scalia could have foreseen. Right? It's sort of evolved. Right? What was a neutral law? What was a generally applicable law 30 years ago? And then I think the COVID epidemic has really thrown things for a loop. All right, so where are we today? RFRA is now unpopular in many states, right? I suspect some states will repeal the RFRAs. I think Connecticut has one. I think they'll probably repeal it. There's probably movements to repeal them. Why? Two major issues. One is birth control. The second is LGBT rights. These are two issues where free exercise of religion has clashed head on with where you have this head on clash between free exercise of religion and any sort of progressive social issues. I don't assign it anymore, but it's in your book, the Hobby Lobby case. I don't have time for everything. But this was a mandate imposed not by the ACA, but by the executive branch that required employers to provide access to contraception. This is not about Griswold and the right to privacy. This is about coverage for insurance. And a lawsuit was brought under RFRA, and the court held 5-4 that the government can't require for-profit corporations to cover them. This was a controversial ruling. You have nonprofit groups like the Little Sisters of the Poor and other charities that have been litigating for years to try and get out of this mandate. Again, I'm not covering those cases, but I'm trying to give you the sort of backdrop of where we are today. We also have gay rights issues. The Philadelphia case we'll come to in a moment. But a couple years ago, another case involving the Masterpiece Cake Shop. Right, this is a bakery outside of Denver. I was giving a talk at a law school in Denver a couple years ago, And I actually drove past the bakery. I just wanted to just see it. It was closed. They were on vacation. I was going to go buy something just to kind of check it out. But the bakery there would not make a cake for a same-sex wedding. I am simplifying the facts immensely, but that's the short version, right? They would make a gay cake couple for a gay couple, but they wouldn't make it for a gay wedding or commitment ceremony, as it were at the time. That case went to the Supreme Court, and there were allegations of violations of free speech. You can't make me build a cake. And also religion. The court found there was some evidence of animus under Lukumi, that there were members of the Colorado Civil Rights Commission, I can't remember the name, that made some hostile comments about religion. That was just a duck to get Justice Kennedy's vote. It was a garbage opinion, right? It didn't actually resolve the meat of the issue, because if you have some other civil rights board that keeps her mouth shut, you don't get to targeting. Right. And so it didn't address the core issue of how to resolve these conflicts between speech, religion, and gay rights. It just sort of ducked it because that's what Justice Kennedy wanted to do, and that's all they could do. Well, he's gone, as I've often reminded you, and this is the big case for the term. It involves something that is really personal to people, which is children. As now a father, right? There's not much more that people get emotional about than family and children. Something that really, cuts to the core of how people define themselves, right? Not just, children that they have of their own, but even children that are adopted. And in many cases, adopted children have even stronger kinship because, well, this is kind of awful, but they were wanted, right? Not all pregnancies are wanted, but when you're adopting a kid, you are doing it quite deliberately because you want to bring a child up in this world, and it's a wonderful thing to be a foster parent. It's a wonderful thing to be adopted. I've not done that, but I have friends who have it. It's a very noble act to bring a child into your world and raise it. So this is a very personal issue. All right. So let's try to break this down. Let me try and get the facts. I know I'm lecturing a lot because it's not you don't have all the facts. I didn't make you read the entire case. I'm going to do a little more lecturing, but we'll get to. Let me stop. Any questions so far? Let me just stop for a minute. I've gone on for almost 30 minutes. Any questions so far? Yeah, Victoria, go ahead.
I just have a quick question about how you were talking with the Sherbert test and COVID. Because I feel like if the state is in a pandemic situation, that they would have a compelling interest to be able to shut down. Like, how would it not pass the Sherbert test?
Well, that's a good question. So, compelling interest. Okay, I'll give you that one. Is a complete prohibition on worship the least restrictive means?
It's not a prohibition on worship. It's just congregation, right?
Well, for some people, they have to worship in groups. They can't worship alone. Some prayers can't be said alone.
I get it.
Let me try it a different way, Victoria. You're asking a really, I think a really good question. Let's say a church is allowed to have 50 people eat together in a space if they're operating as a soup kitchen for homeless people, right? Which is in most states, there were no limits on soup kitchens. They were socially distanced, but they can have as many people as they want, right? I'm talking about a sanctuary, they can fit 1,000 people, but they're limited to 10 worshipers. Is that the most least restrictive means that only 10 people can be there? Maybe you space them out, right? If you've been in an airplane last year, you're sitting 6 inches away from someone else. There's no distance. You have some of these cathedrals, like St. Patrick's Cathedral in New York, is like 1,000 people can fit, but you're limited to 10. So I don't think this passes Sherbert. This is not the least restrictive means. Sherbert's basically impossible to satisfy. It's not just narrowly tailored; it's the most narrowly tailored approach.
I feel like it's useless then.
What's useless?
The Sherbert test. If it's not workable,
Well, that's what Scalia said, right? That's what Scalia said in Smith. I'm sorry, this guy's leaf blowing inside my window. I apologize. They always come by during class. That was Scalia's point. Scalia said it's a worthless test. It's unworkable. Is that where you were? Is that where you agree with Scalia then in Smith?
This is a very rare moment, but yes, I guess.
Ain't that funny, right? Yeah. This is a case where people get flipped around. But yeah, thanks, Tori. Appreciate that. All right, yeah, people, they always come by leaf blowing right during middle class. All right, other questions before I move on to the facts of the Fulton case? Yeah, Mackenzie, go ahead.
So you said that most states are it's unpopular. RFRA is becoming unpopular in most states now.
I didn't say most, but in many progressive states, many blue states, it's coming under attack. The ACLU, the American Civil Liberties Union, supported RFRA in 1991, 92. They no longer support it. They've actually withdrawn their support. So there's been a serious sea change in the statute over the last 30 odd years.
And these groups like the ACLU, they're in favor of like the Smith or a different test completely.
They're a little vague on what they would like to replace RFRA, but the implication is if you get rid of RFRA, you're stuck with Smith. Yeah, I mean, they're basically going to say as long as the law is neutral and generally applicable, we can burden religion. That's what their position will be. Yeah. Thank you, Mackenzie. Good question. Yeah, I think that's in the reading I gave. I think it's referenced that even the ACLU is backed off of RFRA. I think that's in the reading I gave you for today. And by the way, the ACLU is the American Civil Liberties Union. It's a very prominent civil rights group, if you don't know what it is. All right. So that brings us to the Fulton case. The facts here are messy. And it's not because I'm a bad professor to explain it, but the parties don't agree on the facts. And I don't know if I can actually do an honest job of describing the facts because I'll piss off one of the sides. So I'll do my best to sort of simplify it, maybe even change the facts a little bit, but recognize that they don't even agree on what the facts are. In the city of Philadelphia, you have a group called the Catholic Charities. They've been operating for like almost 200 years, right? They've been helping to place Catholic Social Services. It's called different things, different cities. Catholic Social Services. They've been helping to place children with foster parents and adoptive parents for a very, very long time. And they've done this on their own for the longest time. In other words, they didn't need the government's permission for the longest time. But in the 20th century, the state began to get more involved in the foster care process, with perhaps good reason, right? If you're putting children in, temporary or forever homes, you have to make sure these people are not criminals and they're not going to abuse the kids and they have the means to care for them. I think that's it's a worthwhile measure. So what happens is the city would work with these various charities to sort of screen families, right? In other words, if I'm looking to adopt, I would go to Catholic Social Services, say, hey, here's me and here's my family and I want to adopt and I have a house, I have a stable job, here's my, situation. And then the charity would then make a recommendation to the government, to the city. And in turn, the city would say, okay, yeah, Josh, you can get a foster child. And then they sort of place the child with the family, right? So the role of the Catholic Social Services is debated. Philadelphia says that the charity is just a contractor, right? In other words, the same way if I hire someone to mow my lawn in the middle of First Amendment class, right? He's a contractor. And I can usually dictate the terms of a contractor. If the government hires a contractor, they can restrict the contractor's rights, right? When you're on the government's payroll, you have to give up some of your rights. So Philadelphia argues, no, these are just contractors, right? The city is contracting with Catholic Social Services. As a result, they can't raise these sorts of free exercise issues. They're simply going through a job. If they don't want to comply with our terms, then they don't have to do it. They don't have to do this job, right? We're not telling them how to worship, how to pray. They just don't have to work for the city. Maybe they can, help children other ways. Charity, food drives, public school education, whatever, right? So the city says there's no free exercise issue. This is all about a contractor. Okay, the church, the Catholic Church comes back and says, no, that's not right. This is a license, right? We've been doing this job for 200 years. We want to do this job consistent with our faith. And you're saying that we can't do it consistent with our faith, right? You're telling us that our religious beliefs about gay marriage are inappropriate, and you can't have this. So again, the parties don't even agree on the facts. I'm not going to try to mediate that here. The court will have to make up its mind in the next few months or not. They sometimes just don't decide issues, which is why I don't like this case very much. It's very messy. It's not clean. All right, so those are the facts. Let's just assume, for present purposes, that the church is correct on the facts, because it makes the case easy. If the city of Philadelphia is right, this is not even a Smith case. It's just a government contracting case. It's kind of boring. So let's just, for argument's sake, for the sake of discussion, assume the church is right, that this is a license on their religion. Okay. Is this law neutral and generally applicable? All right, I'm going to start calling on people now. I've been talking for almost an hour. Who am I up to? Where am I on the list? Does anyone even know? Who's next? Who did I call in last class last?
I think you called on me last class.
I did call on you last class. Baker. I think Baker, you next? I think you're next, actually. Baker? No Baker. Tori, you here? Huddleston? H?
Yes.
I have two Tories, I'm sorry. Tori H. Okay. All right. So is this law neutral, Tori?
And we're looking at if the church is correct, if the Catholic Church.
Yeah, I just think of argument. You don't have to agree with it. Just assume the church is correct with how the facts are. Is this requirement that the church must interview gay parents? They can't turn gay parents away. Is this law neutral and generally applicable?
Yes.
Okay, tell me. Whoa, hold on. Oh, you got it. You got to give me one. It's got to be yes or no. It can't be yes or no, right? Which one is it?
With yes.
Okay, so you final answer, right?
I think so.
Okay, so now defend it. Tell me why you think it's neutral and generally applicable.
I mean, I'm not really understanding, so I'll just say what I think. Is it just because is this where? Okay, I'm sorry, I'm a little confused. Is this
what does it mean for law to be neutral and generally applicable? Let's start there.
I don't really know.
Well, what was the law at issue in Smith?
Well, so it's it's really apply with the valid and neutral law of general on the ground that the law makes criminal conduct. So okay, can you repeat the question? I'm sorry.
What was the law in Smith?
Was it the native, the peyote one?
What was the law, though? What was the actual law?
I don't remember. I'm sorry.
Okay, I'm going to move on. Samia, are you here? Samia? What was the law in Smith?
Are you talking to me?
No, Samia J. I got people with multiple same last names. No, there's Samiha and Samia.
I'm Samia, she's Samia.
Samia, I'm sorry. I apologize. Samia, I'll try to get that right. What was the law in Smith, Samia?
They said that the state could refuse to carve out an exception.
No, what was the law? Just what the law enacted by the state, just really simple.
That a state didn't have to comply, they didn't have to.
What was illegal in Oregon?
Doing illegal drugs.
Yeah. The crime was you couldn't do controlled substance peyote, right? Simple. What is the law here in Philadelphia?
That anyone can foster a child, or they feel that anyone should be able to.
Well, no, but you're telling me the effect. What's the actual law in Philadelphia? What are the foster care charities required or prohibited from doing?
From fostering children.
No. What is this case about? What is this case about?
Whether.
Let's put your hands down. We're no, don't put it in the chat. I want to. If people don't know this, we're gonna have to sweat it out a bit.
Whether the CSS should be able to.
What is the law? What are they challenging in this case?
The religious exercise.
What are they challenging? What don't they like that Philadelphia did? What was this case about? No. Lewis, you're next. I think your hand was up as well.
Is this case about like whether they can discriminate against gay couples?
Okay, so let me. You gave me the right answer. Let me just sort of flip what you said. What are the charities not allowed to do? What's prohibited?
They're not allowed to discriminate against gay couples when it comes to fostering or adopting kids.
Is it only gay couples, or are there other bases?
I think it's just gay couples.
What do you? Generally, are discrimination laws only on sexual orientation? What do they usually cover?
Oh, it's like the LGBT community.
Even beyond that, can they say we won't give children to black couples?
Yeah, I guess race as well.
Well, I mean, yeah, is race discrimination prohibited or allowed? Yeah, it's a little bit.
No, race discrimination is
Okay.
not. Is not
Okay, all right. Thanks, Lewis. Okay, good. All right, that took way too long, guys. Thank you. This case, when I'm asking what's being challenged, I'm asking for a law, right? And Philadelphia law says that you can't discriminate on a number of bases. Of course, race, religion, right? Gender, and Philadelphia also includes sexual orientation. Okay. Now we got that settled. Avery, are you here? Avery? No. Moises, you here?
Yes, I'm here.
Moises, is the Philadelphia non-discrimination law neutral and generally applicable?
I think that's what the issue is.
Of course it is. I'm asking your opinion.
Yeah.
I appreciate the response, but that's my question to you. Is it neutral and generally applicable?
I think it is, but the Fulton's position is that it isn't.
Okay, well, give me both sides. And why do you think it is? And then why does the church say it's not?
I think it is generally applicable because it's not directly focusing on the CSS. It's saying no one can discriminate against same-sex couples when dealing with foster care. But also in Fulton's view, or in the church's view, it reminds me of the Church of the Lukumi case, that the city had enacted an ordinance as soon as it had discovered information about the church. And just like in this case, when the person that made the rule discovered that the leader of the archdiocese, or one of the leaders of the church, still felt that same-sex marriage was not right, and that they were not going to give same-sex couples the ability to foster, then that alone, I think, could be a good argument that it's not generally applicable.
So you said there might be evidence of targeting or animus
Right.
towards Catholics.
Just because the rule was enacted right after they received that information.
All right, really good. Thank you, Moises. Excellent answer. Yeah, that took too long, guys. You gotta get better participation. If I'm calling you and you're not going to answer right away, it's you have to do the reading better. I'm sorry. This is a 2L class or 3L class, so I can't hold hands like I would in a 1L class. I have to move on. But thank you. That's very good. Is the law in Philadelphia neutral and generally applicable? Ask me, probably. Right? There are lots of anti-discrimination laws that are enacted across the country, right? And generally, I have to use the word generally, but in almost all these cases, these laws are not designed to burden religion, right? These laws are designed to eliminate various forms of discrimination in the workplace and other areas of society, right? Jessica, 2 seconds, and Blake, another second, right? But there is some evidence that the church brings forward, and Moises alluded to, that the history of this law makes it unique. This was not a law that had been enacted, long ago. It was sort of on the books. This is a law that was enacted, perhaps, I'm not saying it is, I'm saying the argument, because the city of Philadelphia didn't like the religious views of the Catholic services. And in fact, there were some comments in the record, I don't remember if this was in your reading or not, where someone said, why can't you be a Pope Francis Catholic, right? Which maybe doesn't mean the same thing now because the Catholic Church didn't go that direction. But there was why can't you be more modern, progressive Catholic? And that, in my mind, might be where the court jumps off and says targeting. I'll get to the Cuomo story in a minute. Right? Okay, I see Blake. Actually, Blake's first, then Jessica. Blake, go ahead.
Reading through the SCOTUS blog, the first thing that threw me was Alito's comment that it just seems to be a challenge on gay marriage when it's not. And I mean, I can say that from being LGBTQ and knowing that I would love to be able to adopt sometime in my life. So that comment seemed a little bit tone deaf. But going back to like the general applicability, gay rights doesn't happen overnight. Equality for same-sex couples does not happen overnight. We waited years and years for Obergefell to come through. Now we have to figure out what other challenges are faced in different jurisdictions and areas of our country and assess them as it goes. And also, as having grown up Catholic and still being part of the faith, it's hard to prove a sincere belief when you have a pope that is open to everybody and you see all these different sects of the Catholic religion going one way or another. It's going to be really hard to settle on one belief, especially when it's not settled even in doctrinal teachings of the church. So it's a complicated case. I have lots of thoughts on it, but those were some of the big things that I thought about reading through all these things.
Yeah, let me address just the part of it. What exactly is the teaching of the church? The courts will not get involved in deciding what are the doctrines of a church, right? They won't say, "Oh, you're wrong. The prohibition on gay rights is only in this teaching, but not in that teaching," right? But the courts will assess if someone sincerely holds those beliefs. So, right. So let's just take the Amish, for example, right? During the Vietnam War and the draft, lots of people found the Quaker faith to be very pleasing because it's pacifist. And a lot of people become Amish saying, "Oh my God, if I become a Quaker, become Amish, I can get out of the draft." Okay. The court says, bullshit, right? You're not sincerely an Amish, right? You just want to get out of the draft. So the courts will determine if a person sincerely holds beliefs. But the courts won't get involved in deciding what the tenets of those faith are. So I want to just pick up that one point you make. I think it's actually an astute point. Jessica, is your hands up? Oh, you're on mute, please.
Yes, I was just going to comment on the fact that I know you probably are going to get to it, but it also mentioned that there was a waiver system in place already.
Oh, what's it? Well, I didn't hear what word you said.
In the petitioner's brief, it mentioned the waiver system.
Oh, yeah, the waivers are important. Yeah.
So at first I thought it was facially neutral, and then I read all those things, and I thought, well, it can't be neutral if these people can't apply for a waiver, or at least it can't be discussed. And then I wondered, when you're assessing these things, it's a balancing. It's just a natural balancing, I guess. You look at the facial neutrality, and then you still go further, even though it looks okay on the surface. You have to.
Yeah. Let me get to that. Thank you for that, Jessica. So one of the ways you determine if something's neutral is these concepts of over-inclusiveness and under-inclusiveness, right? They have this policy, you can't discriminate, but you can also seek a waiver. And if they're trying to grant waivers, that suggests the state isn't really interested in banning all forms of discrimination. Maybe they're going to do it on a selective basis. In other words, they'll give it to Group A, but not to the Catholic Charity Services. There's also the issue, and again, this is very fact-bound, of whether they will, for example, give a foster child to a disabled parent, right? Let's say a parent's a quadriplegic and can't care for himself, and he applies to be a foster parent, right? That application will probably not be granted. And we can all discuss reasons why, but you have to be able to care for the child. So they actually do have a ban on disability discrimination, but they won't give it in some cases to disabled parents or disabled foster parents. And then the city argues, well, that's different. That's why placing the child will still screen them, right? So even then, the facts are so messy here. I'm not looking forward to this decision because it's going to be hard to teach, which is why it's the way I look at cases. All right. So let's assume that this is not a law of general applicability. We'll just take the church's argument for a minute. This is not a law of general applicability. Who's next on my list? Dina, you here?
Yeah.
Okay, Dina. Let's just assume the church is right. This is not a law of general applicability. Okay.
Okay.
Does the city of Philadelphia use the least restrictive means to accomplish their goal?
Probably not.
Why not? How else could you ensure that, I'm playing devil's advocate perhaps, How else could you ensure that gay parents have the ability to adopt foster children without this law? What else could the city do?
I mean, they could ensure that there were some options.
Oh, are there other charity groups in Philadelphia that help place children?
Yeah.
There are a lot of them. In fact, I think Catholic Charities, I might be wrong with this, I think Catholic Charities is the only one in Philadelphia that wouldn't go to a gay couple, that wouldn't accept a gay couple, right? So, Dean, I mean, if you were a gay couple in Philadelphia, would you be unable to adopt a child?
No,
Would it be easy enough for you to find another agency?
probably.
Okay, so if we're in strict scrutiny land, right? Thank you, Dina. Very good. If we're in strict scrutiny land and we're dealing with a law that's not generally applicable, right? The church is right. This law would not survive. It wouldn't survive RIFRA either, right? There's so many other ways that the state can ensure that gay parents are given options to adopt other than requiring this one Catholic group to participate, right? Maybe the state could go out of its way to recruit, LGBT-friendly adoption groups, right? There are different ways the state could accomplish this. So if you're under this, the sort of Sherbert, the strict scrutiny standard, this doesn't fly. Okay, Alexandra, are you here?
Yes, I'm here.
Okay, Alexandra, thank you. Okay, let's take the other side for a minute. Let's say that the city is correct, Philadelphia is correct, and that this is a neutral and generally applicable law. Okay?
Okay.
Does this law survive the rational basis review? Does it survive Smith?
I'm not sure that it would.
Okay, tell me why.
Well, because under rational basis review, with all of the other options for LGBTQ couples, I think under a rational basis review, you would still find that there was sufficient options for fostering through the city.
So you still don't think so you think the city would even lose under Smith?
I think maybe.
Okay, that's a fair point. I'm almost out of time, so unfortunately I'm not going to have too much time to ask a second, third person. I would usually do that, but I got like 2 minutes left. Let me just leave you here with a few thoughts, and if you want to talk later, happy to chat later. Thank you, Alexandria. The Third Circuit, the lower court, basically said if Philadelphia loses under Smith, then Smith is meaningless, right? Then we're basically back to the Sherbert test, right? The lower court said there's no way Philadelphia loses this case under Smith. I go back and forth. I think the waiver issue is actually very tricky and very fact-bound. I also think the intent issue with the targeting is tricky because people said stupid things in the record that they probably shouldn't have said, right? But maybe that illustrates why Smith is not the best test. It requires you to sort of look, peek under the curtains, to use the words of the Fulton case, to try and figure out what's going on. Even if Smith is not retained, though, that doesn't mean you go back to Sherbert. Someone said that Sherbert's meaningless, or I forgot what word you used. It's basically an impossible to satisfy test. Maybe there's some other test that fits somewhere in between Smith and Sherbert, right? Maybe neither test is correct. I think the court has not explained either test why we have it, right? Justice Brennan kind of just made it up, and then Justice Scalia kind of made his up, right? They both kind of made up their test without any resort to text or history. It's entirely possible that the court says, we keep Smith on paper, but we're going to redefine what neutral means. Right? We'll keep Smith on paper, redefine what neutral means. And if the court does that, then it's possible that the charity wins this case, but other harder cases might go for the government. I don't know what to do here. I don't think they overrule Smith. I gave you that reading. I think it's unlikely. Even Justice Barrett was saying, whoa, whoa, whoa. And she cleared for Scalia, whoa, whoa, we're not overruling Smith. I think there are probably 2 or 3 votes to overrule Smith, not much more than that. So we're stuck with Smith. Beyond that, I don't know what the court's going to do. And I doubt this case will be decided before your final. Even if it is, I won't expect you to know the decision, if it comes out like, May 15th, right before your exam. I'm not expect you to know it. But I encourage you to sort of keep your eyes and ears open as informed citizens. And, if you want to talk about it next semester, I'll be happy to. All right. I am out of time. Any questions? Yeah, Denver, go ahead.
guess I'm having a hard time understanding how this wouldn't be generally applicable, given that it would. I'm assuming. I mean, we didn't read the whole case today, so I don't know all the facts and like the exact law. But I'm assuming that this would apply to any kind of private charitable organization that acts as a contractor that has like discriminatory screening practices, right?
Well, again, if it's actually a contractor, this is an easy case, but that's not clear.
Well, but that would apply to all like faith-based organizations that.
Right. If you're, I mean, again, Justice Thomas asked this question during the argument. What's the difference between licensing and a contractor? It's a very subtle standard. Okay. The minute poll's running. Hope you guys can fill it in. Otherwise, I'll office hours. I can't do 2 for 45 today. I have a call, but maybe at 4 o'clock we'll do a office hours. I'll be happy to stick around. So 4 o'clock today. All right, everyone. Thank you so much. Have a wonderful day, and we'll see you all on Monday.